They're the forensic detectives cracking cases with science. Hollywood heroes revealing the secrets of the dead. And Adelaide thought it had a real-life CSI star when Dr Colin Manock arrived to become South Australia's Chief Forensic Officer.
He was very much like the pop star of forensic pathology.
There are very good reasons for carrying out post-mortem examinations.
But we're about to reveal what a terrible mistake that was.
Dr Manock isn't a forensic pathologist. He's a charlatan.
Tonight, a scandal unparalleled in the Western world. A forensic pathologist whose trail of incompetence is hard to believe.
This man has gone completely rogue.
Thousands of autopsies, wrongful convictions, innocents jailed, and potential killers gone free.
Just think about how many families Manock has ruined.
And we investigate those who allowed Dr Colin Manock to operate for so long. The truth is, people knew.
Legal authorities knew and failed to do anything to stop him.
Good evening, I'm Liz Hayes, and this is Under Investigation. March 1968. The South Australian health authorities are looking for a forensic pathologist to become the state's top forensic expert at Adelaide's Institute of Medical and Veterinary Science. It's a role with immense responsibility. The successful applicant will carry out or supervise all autopsies in the state and testify in criminal trials, often being the persuasive voice in innocence or guilt. A young lecturer at Leeds University in the UK applies for the job. His name is Dr Colin Manock.
Adelaide, being quite Anglophile, would have said there's this man from England who speaks very confidently, who probably knows what he's saying.
Manock was vastly inexperienced for this senior job, and yet he got it and moved to Adelaide that same year.
He was a UK university lecturer. It all looks great.
A series of post-mortem examinations following a medical death certificate showed about 50% were wrong.
He's got a polished accent and he sounds as though he's very convincing and he presents very well. That's just a recipe for disaster, because it was all covering up the fact that he didn't have the qualifications.
The South Australian authorities urged Manock to obtain the qualifications he lacked, but he never would. Because he knew that he didn't have the qualification, didn't he?
Of course he did, absolutely. If anybody knew, he knew.
Joining me tonight, experts who'll help unmask those responsible for Dr Manock's seemingly irresistible rise. Knowingly employing someone who didn't have the qualification. That's really where it started. They knew.
Well, that's the problem.
Dr Robert Moles, an Adelaide lawyer who waged a 30-year campaign to reveal the truth about Manock.
They had him doing the work, knowing all the time. He actually wasn't qualified to do it at all.
Professor Bibi Sanga of Flinders University, who tried to overturn convictions based on Manock's flawed forensic reports.
The role of a forensic pathologist is probably more important than that of a prosecutor, a judge, a jury. So it's almost like a godlike figure.
Jeffrey Watson, SC, leading Sydney barrister, who is calling for a public inquiry into the Manock scandal.
When you talk about the size of the scandal, what I can't understand is that this could go on for so long. I can imagine a liar fooling people, judges, juries, lawyers, for say 3 years, maybe even 5 years. This went on for 30 years.
And from London, forensic pathologist Dr Richard Shepherd, who's performed more than 23,000 autopsies, including that of Princess Diana.
It is just an unbelievable set of situations. When people began to realise the problems that were causing, why didn't they do something then to stop him?
Once he was given the job as South Australia's preeminent forensic pathologist, Dr Manock gave expert testimony in case after case. And almost from the start, he began to get them terribly wrong. July the 15th, 1971. A 15-year-old girl, Deborah Leach, is found murdered on an Adelaide beach. She was last seen alive at 4 p.m. that day. Her stomach contents will ultimately convict the police suspect, Fritz van Beelen, because Dr Manock claimed they enabled him to establish an accurate time of death. And he put that time of death precisely at 4:30 p.m. Any later, and Van Beelen wouldn't have been at the beach and could not have committed the crime. But even in the 1970s, this was highly dubious science, and it was devastating for Fritz van Beelen. He was sentenced to death, later commuted to life in prison. Dr Richard Shepherd, acknowledged as one of the world's leading forensic pathologists, has a very clear opinion of Manock's claim.
Richard, you've looked at this case. Can you determine time of death through stomach contents?
The history of forensic pathologists determining the time of a death is littered with disasters like this. The answer to your question is no, you cannot in any way, shape or form determine the time of death.
Well, he was adamant, wasn't he, Bob Moles?
Yes, he was.
Because he was pushed on this.
Van Beelen's defence lawyer at the time said, could you be sure that she was dead by 4:30 and no later? Dr Manock said that he could, and he was then pressed, well, maybe 5 or 10 minutes. No, couldn't be 5 or 10 minutes later.
You cannot be that precise. It simply is not possible. He's using something that is very shady, very dodgy, even at that time, and he's expressing a view that subtly chimes in exactly what the police and the prosecution want him to say. So I look on it and I just say it is complete rubbish. You cannot make that assessment.
It is influential in a court, this kind of statement.
This sort of evidence, it's devastating. That's what juries latch onto. It turns cases, and he would have known that he was doing that. He would have known time after time after time that his evidence was crucial.
Coming up, Dr Manock goes from bad
To conduct an autopsy in public
to outrageous
Can you imagine anything more horrendous?
as our case against him mounts
This seems to have been a diagnosis literally plucked from the air.
and his evidence goes unchecked.
Who knew what in South Australia at the critical time?
The prosecutor in the Emily Perry case is now one of Australia's leading judges.
That's next on Under Investigation. It's a legal scandal unlike any other in the world. The extraordinary case of Dr Colin Manock, for decades South Australia's chief forensic officer, who was never qualified to hold the job, whose very questionable scientific opinion helped send men and women to prison for murders they didn't commit. As our investigation continues, we'll examine the roles of senior legal figures in South Australia whose actions allowed Manock to operate, but who have never been called to account.
It was a real collusion by the whole coronial legal system to accept Dr Manock as being an expert when, in fact, he clearly wasn't.
By the late 1970s, Manock's forensic opinions and his methods are virtually unchallengeable. He's testified in scores of criminal cases and conducted thousands of autopsies. In 1978, he attended to a suspected murder case in the tiny South Australian town of Minturpie.
The victim was an Aboriginal man.
With Manock is a young policeman, Peter Wellham, who claims Manock conducts an autopsy of the body in public.
He advised me he would conduct the post-mortem examination in the open air on Lake Minturpie.
Bob, this young policeman at the time gave an affidavit
Yes, he did.
afterwards to say what he saw because he was so devastated.
It's horrendous. I mean, we're talking about a small Aboriginal town, and Dr Manock asks for 2 empty oil drums to be brought over, a sheet of corrugated iron to be placed on top, for the man's body to be stripped off and placed on top of the corrugated iron, and then he takes out his tools and begins to open up the chest of the man.
Dr Manock dipped a metal ladle into the bodily fluids and blood within the trunk of the body. He held the ladle in front of him at arm's length and facing the gathered group, he commented loudly, "Anyone for soup?"
Can you imagine anything more horrendous?
I think Peter Wellham said that he had actually sought a more private location
Yes.
at the pub, I think,
Yes.
and had approval to do that. And Dr Manock rejected that idea.
That's right. He said, there's a pub over there, it's got a cool room attached to it, and Dr Manock said, no, we're actually going to do it in front of everybody and treat it as a bit of theatre.
It's a tiny, tiny town, and to conduct an autopsy in public on some corrugated iron held up by a couple of drums when he had options to do it elsewhere. Talk me through your thoughts, Richard.
I simply cannot believe that any person, any doctor, any pathologist would do that. I just think this is such a degrading act. I actually have no words that I can think of to describe this. I cannot believe that anyone would do this in any way, unless they were aiming to show their power and domination. This speaks more to the man's psychology than his obvious fundamental lack of pathology.
July the 24th, 1981. Emily Perry, Adelaide's so-called Black Widow, is convicted following Dr Manock's testimony that she tried to poison her husband Ken with arsenic. It will later be shown that Ken Perry may have accidentally ingested arsenic from rat poison, found in old pianolas that he could have come into contact with while restoring them. Ken, though, is never physically examined by Dr Manock. But in court, as the state's expert witness, Manock paints a picture of a meticulous murder attempt by the 55-year-old Mrs. Perry. She is convicted and sentenced to 15 years hard labour.
Richard, how on earth do you think Dr Manock could have come to these conclusions?
This seems to have been a diagnosis literally plucked from the air.
But it's interesting that in both Emily Perry case and in a number of other cases, Manock was often criticised for engaging in speculation, and that was the consistent theme. He would speculate to the 10th degree, and nobody ever sort of really pulled him up until things started unravelling.
And the law's quite clear. Speculation is not admissible on the part of an expert witness.
But having relied on Dr Manock's emphatic but very dubious scientific testimony to convict Mrs. Perry, the prosecution's case was thrown out in the Australian High Court. One of the judges, Justice Lionel Murphy, went as far as to say that Dr Manock's forensic evidence was not fit to be taken into consideration.
Lionel Murphy, Jeffrey, was pretty clear in what he thought about Dr Manock. I mean, how quickly would that have got around?
Justice Murphy knew that Manock was not qualified, and he was saying it. In terms of the impact of a decision by a High Court judge telling a prosecuting authority that they should not use a witness, that's devastating. You would never come back from that. In an ordinary world, that would mean that that expert would no longer be testifying in critical cases.
But he is, so what does that say?
This won't be the last time that I say this. What we don't know is who knew what in South Australia at the critical times and why they weren't doing something about this.
I think the interesting thing is that the prosecutor in the Emily Perry case is now one of Australia's leading judges.
Brian Martin, KC, became a South Australian Supreme Court judge, then Chief Justice of the Northern Territory Supreme Court, and has served in other senior judicial roles. A prosecutor in the 1980s, he was aware Dr Manock's work in the Emily Perry case was thoroughly discredited in the High Court. But as you'll see, he used Manock as an expert forensic witness in another high-profile case just 3 years later.
Jeffrey, is the prosecutor legally required to advise of this deficiency?
Prosecutor's duties are very, very different to those of an ordinary barrister because a prosecutor is not seeking a successful result at all costs.
Leading Sydney barrister Geoffrey Watson says it's incumbent upon prosecutors to ensure the veracity of their expert witnesses.
You're representing the people, the state, and what we're actually after as people, as a state, is a fair trial and a fair conviction, and what we're seeking to avoid is an unfair conviction. So the duties cast upon a prosecutor are different, they're more onerous, and I just cannot understand how Manock could have been presented to a jury as a man of science following Justice Murphy's judgment.
But Manock continued to give evidence, and his competence continued to be questioned. In 1984, in the case of young Aboriginal man Gerald Warren, his work appeared to border on the absurd. Dr Manock determined Gerald Warren had died after accidentally falling from a moving car. Strange markings found on Warren's face and hand were, according to Manock, impressions made in the skin from his corduroy jeans.
Whilst the young man fell from a moving vehicle, his face and his hand must have come into contact with his corduroy trousers that caused these marks. It was subsequently established that, in fact, he'd been beaten with the threaded end of a metal scaffolding pipe, and then he'd been run over by a utility vehicle, backwards and forwards, on several times.
Two men would eventually confess to beating Gerald Warren to death and repeatedly driving over his body. Then, in 1992, came the death of Peter Marshall.
Now, Peter Marshall is an extraordinary case. This is a man who was found on the floor in his bedroom with a pool of blood.
Dr Manock examined him and failed to realise he'd been shot.
Dr Manock decided he'd had an aneurysm or fallen from his bed.
That's correct, yes. He had been sleeping in his unit, which is on the ground floor, with the window open, and apparently his body was found beside his bed with blood pooling around his head. And Dr Manock, when he visited the scene, said, I think he might have bumped his head on the bedside cabinet as he fell out of bed, or he might have had an aneurysm. So it's not a suspicious death. And so the body was taken back to the mortuary. And it was only a couple of days later that they put the body through a scanner and found, of course, he'd been shot in the head and he's got a bullet lodged in his brain.
Far from dying of natural causes, as Dr Manock had initially found, it was believed Marshall was the victim of a suspected domestic dispute. Again, Manock had spectacularly missed a murder. Two suspects in the case died before charges could be brought against them.
Richard.
This is just unbelievable. I cannot even begin to pick the holes that are so obvious. He will just say anything. It seems to me this man has gone completely rogue. He's just thinking what he wants to think, and there is no challenge.
Coming up,
Jeffrey, the Keogh case, another alarm bell?
By this stage, the fire is raging. It's burning down the house.
how Manock's flawed evidence helped put a man behind bars for 20 years.
Institutional failure on a massive scale.
That's next on Under Investigation. The case of Dr. Colin Manock is one of the world's most unforgivable legal scandals. In our investigation tonight, we've shown how the barely qualified pathologist held South Australia's most senior forensic post for decades, despite case after case where he got it terribly wrong. A man sentenced to death, a public autopsy, and 2 cases of murder that Manock completely missed.
This is just unbelievable. I cannot even begin to pick the holes that are so obvious.
But if what Manock did is shocking in the extreme, perhaps equally shocking is how he got away with it. As our investigation continues, we'll examine 3 cases involving senior South Australian judicial officers who, by their actions, excused Manock's incompetence and highly dubious testimony and allowed a grave injustice to occur.
Where it goes wrong is when he's presented to courts, to juries, as an expert, and that's just inexcusable.
The prosecutor, the coroner, and South Australia's former Solicitor General.
When people began to realise the problems that were causing, why didn't they do something then to stop him?
Between 1994 and 1995, Adelaide coroner Wayne Chevelle held an inquest into the deaths of 3 babies who had died suddenly in separate incidents. 3-month-old Storm Dean, 9-month-old Billy Barnard, and Joshua Nottle, also aged 9 months. Dr Colin Manock had conducted the autopsies and found all 3 babies died of natural causes or rough play. But Coroner Chevelle's inquiry revealed shocking injuries, completely missed or utterly misread by Dr Manock.
These were cases where I think the police finally thought, this is just not right. They brought their concerns to other doctors, and then they went to see the coroner and said, we have got serious reservations about the autopsies.
Richard Shepherd, Dr Manock suggested some of these injuries were the result of rough play, resuscitation, a birth trauma. What did you see when you looked at that?
Well, I think the description of the injuries, the x-rays, the photographs, they are just screaming child abuse. They are screaming out that this child has been injured deliberately, non-accidental injuries. I think it was a fractured spine, multiple fractured ribs, fractured limbs. These things just do not happen. And they don't happen even in the roughest of play, in the most devastating circumstances. This is child abuse. It has to be.
Coroner Chevelle concluded Manock's autopsies were so flawed they'd achieved the opposite of its proper purpose and had prevented police investigating potential crimes of child abuse or even murder.
Jeffrey, crimes potentially were committed and no one answered to them.
I suppose when you look at the terrible, terrible things that happen in our community, you get very few worse than taking away the life of a baby. And here, I mean, I've read the coroner's report, it's quite clear what happened here. Manock, he missed a skull fracture which was available on an x-ray. He described a cigarette burn on a baby's buttock as having been unresolved nappy rash.
And the coroner said that Dr Manock had claimed to have seen things that could not have been seen, and that in answer to some of the questions on oath, he'd given answers that were spurious, which really means not honest.
Richard, how is it that a forensic pathologist can examine the bodies of 3 babies who have some serious physical injuries and decide it's pneumonia?
Well, I think we've established that Dr Manock isn't a forensic pathologist. What strikes me as interest is it is only when he goes against the police, against the prosecution, against taking people to trial for murder, that the state seems to suddenly swing against him. Finally, it is beginning to become clear what a desperately incompetent, awful pathologist this man was.
Wayne Chevelle's report was utterly damning of Dr Manock, which makes what happened next so astonishing. In a separate and unrelated case running at the same time, 41-year-old Henry Keogh was standing trial for the murder of his fiancée, Anna Jane Cheney. Dr Manock was appearing as an expert forensic witness.
Jeffrey, the Keogh case, another alarm bell?
By this stage, the fire is raging. It's burning down the house. Something's got to give here. Something's going to have to happen.
Of course, Coroner Chevelle's report would have immediately cast doubt on Manock's standing as a forensic expert. So, Wayne Chevelle chose not to release it until after the murder case was concluded. But by that stage, Henry Keogh had been convicted, largely on Manock's evidence, and sentenced to 26 years in prison.
I would say that that was a major error because the coroner represents the Crown. The Crown knows that Dr Manock's evidence is unreliable, that he's untruthful, that he claims to have seen things that couldn't have been seen. And then in Mr Keogh's case, he then proceeds to commit all of those same mistakes again.
When the coroner says, I'm not going to release this because it might interfere with the trial, it can only interfere with the trial one way, which is in favour of Mr Keogh. And that itself demonstrates a slanted view on the way that a prosecution should proceed.
Can he do that?
One thing is for certain, that the Crown should not have allowed that trial to proceed if anyone was aware of that information in the prosecution branch. It should have been stopped.
But the prosecutor in the Henry Keogh case should also have been well aware of Manock's failings. As the Director of Public Prosecutions, Paul Rofe QC, had used Manock in many previous trials and must have known the infamous High Court ruling in the Emily Perry case 13 years before, with its damning judgment that Dr Manock's evidence was not fit to be taken into consideration.
At the Henry Keogh trial, the prosecutor held Dr Manock out as the most experienced forensic pathologist with many years of experience, who have conducted thousands of autopsies. So he was in effect telling the jury, this is a man you should trust.
I came home, the house was in semi-darkness, and I saw her slumped, and I hoped, unconscious in the bath. I called out her name, no response, pulled her out.
My fiancée, she's had an accident in the bath. I think she's drowned.
Is she out of the bath now?
I just got her out. I tried mouth to mouth.
You know how to do it?
Yes.
Police initially assumed Keogh's fiancée, Anna, had simply slipped in the bath. Manock had conducted an autopsy, but it was only after Anna's body had been cremated that he took another look at the case. Working only with photographs, most of them black and white, Manock then determined he was looking at a deliberate drowning.
He claimed that there were bruises that supported his theory of a hand grip, where I was supposed to have grabbed Anna's leg, lifted it up, and held her under the water that way.
The bruises Manock claimed were evidence of a grip mark on Anna's leg were much later revealed not to have been bruising at all.
So he had made all that up, and he actually lied about the thumbprint, which was a bruise. It wasn't a bruise at all, nothing there.
Manock's forensic analysis was again tragically wrong, turning Henry Keogh from innocent man to murderer. With two of the state's most senior judicial officers, Coroner Wayne Chevelle and Prosecutor Paul Rofe, having direct and unequivocal knowledge that Manock's evidence in past cases had been discredited.
Institutional failure on a massive scale. He was a bloke who got appointed when he shouldn't have been, and when it was discovered that he wasn't up to the task, they failed to dislodge him.
In a sense, the courts and people, the police, were prepared to accept him, and then it became a self-fulfilling prophecy. You know, he became an expert by the fact that he did it. Now, that's not how we become experts. But the coroner was prepared to accept him, the courts were prepared to accept him. It was a real collusion by the whole coronial legal system to accept Dr Manock as being an expert when, in fact, he clearly wasn't.
But South Australia's judicial behaviour was to become even more questionable in the case of Henry Keogh. In 2004, the state's Solicitor General, Chris Kourakis, received a forensic report finding there was not sufficient evidence Henry Keogh's fiancée Anna was murdered, that instead she had probably fallen accidentally in the bath, as police had suspected at the time. But for reasons that have never been publicly explained, Solicitor General Kourakis, who is now the state's Chief Justice, did not produce that report while in office, and it was not produced for almost a decade, while Henry Keogh languished in prison.
The report was received by the Solicitor General in 2004 and released in 2013, 9 years later. The unfortunate thing is that the Solicitor General in 2004 was then appointed to be a judge of the Supreme Court and today is the Chief Justice in South Australia.
Dr Colin Manock retired in 1995, shortly after his testimony that would help send Henry Keogh to prison for decades.
Henry Keogh's appeal in 2013 finally saw him freed after 20 years.
The man at the centre of one of South Australia's biggest ever legal controversies will be paid more than $2.5 million by the state government.
But is there one final shocking case in Manock's dreadful legacy? Coming up, still behind bars after 38 years.
How important is Manock's testimony in this case?
It's important because it's used to corroborate what the eyewitness said he saw.
Is this man the final casualty of Dr Manock's disgraceful career?
The time has come. South Australia needs to address this issue.
That's next on Under Investigation. Our investigation of South Australia's chief forensic scientist for over 30 years has revealed a shocking trail of incompetence. Innocent men locked up, potential killers gone free, all thanks to Dr Colin Manock. And as we've shown, Manock was seemingly supported at every turn by members of South Australia's legal fraternity. There is one more case we will examine tonight, that of Derek Bromley, who's been behind bars for 38 years. Is he the final casualty of Dr Manock and the system that backed him? It's April the 4th, 1984. The body of 21-year-old Stephen DeCosa is found floating in Adelaide's River Torrens. Derek Bromley, an Aboriginal man, and his alleged accomplice are convicted of murder. The evidence of the only eyewitness will later be questioned due to his severe mental illness, which meant the claims of what he saw were unreliable.
But the eyewitness happened to have been a person who was suffering from a schizoaffective disorder and was having both visual and audible hallucinations on the evening that the event occurred.
Dr Manock gives evidence that directly supports the questionable eyewitness account in which he claimed to have seen a fight near the river.
And Dr Manock gave a description of the injuries that matched the eyewitness description of having been punched, kicked, dragged along the ground and then drowned. But the remarkable thing was the eyewitness account almost exactly matched Dr Manock's account of the injuries having been caused at or about the time of death.
But it's the prosecutor in the Derek Bromley case who also warrants examination. Brian Martin, KC, should have already been fully aware of Dr Manock's failings. As you'll recall, less than 3 years before Derek Bromley was convicted, Martin had successfully prosecuted Emily Perry for the attempted murder of her husband. The High Court threw out that conviction with a damning judgment of Dr Manock's evidence, saying it was not fit to be taken into consideration. But still, Brian Martin used Manock to give evidence when prosecuting Derek Bromley.
Bibi, how important is Manock's testimony in this case?
It's important because it's used to corroborate what the eyewitness said he saw, and also the very particularized injuries that he said were caused just prior to his death.
But according to Adelaide lawyer Robert Moles, other forensic experts said Manock got it completely wrong. The victim's injuries, they said, were more likely to have occurred while the body was in the water. But despite those serious doubts about Manock's forensic evidence, Derek Bromley remains in prison after 38 years. Denied parole because he refuses to admit his guilt.
He's refusing to say he did this crime and that's why he sits there?
Yes, at the end of his non-parole period, after 24 years, he applied for parole and they asked him how he felt about what he did. And he said, look, I'm very sorry, but I actually wasn't there. I didn't do it. And they said, well, that's not acceptable. You're not owning up to your terrible behaviour. And because of that, you're not fit to be released.
Derek Bromley has repeatedly been denied leave to appeal his case. It is now in the hands of Australia's High Court. Remember, it's the same court that in 1982 ruled that Dr Colin Manock's evidence was not fit to be taken into consideration. So our experts believe the High Court should give priority to Derek Bromley, whose 38 years behind bars is inextricably linked to Dr Manock.
We can't get away from the history, and the history shows that miscarriages of justice have occurred because of Dr Manock's lack of expertise.
Yes. Here is a man finding that he has immense power and has just continued blithely making things up and moving things on with the support, it has to be said, of the legal authorities who knew and who failed to do anything to stop him.
Coming up,
all of those cases are in question. We don't know which ones of those might have been murders.
It's a scandal unparalleled in the Western world.
The truth is, people knew.
People knew, very high up in the system.
Yet South Australia still refuses to act.
Just think about how many families Manock has ruined. We deserve the truth.
That's next on Under Investigation.
The role of a forensic pathologist is probably more important than that of a prosecutor, a judge, a jury. So it's almost like a godlike figure.
If only the scandal of Dr Colin Manock was fiction, a book that could be closed and forgotten.
When you talk about the size of the scandal, what I can't understand is that this could go on for so long.
But as we've shown tonight, Dr Manock's disgraceful career was terribly real. And that makes it almost unbelievable.
It was a real collusion by the whole coronial legal system to accept Dr Manock as being an expert when, in fact, he clearly wasn't.
From 1971, when Fritz van Beelen was sentenced to death largely on Manock's dubious evidence.
I can imagine a liar fooling people, judges, juries, lawyers, for say 3 years, maybe even 5 years. This went on for 30 years.
To questions about one of Australia's longest-serving prisoners still in jail after 38 years.
The history shows that miscarriages of justice have occurred because of Dr Manock's lack of expertise.
Yes.
Case after case over decades.
To conduct an autopsy in public.
Can you imagine anything more horrendous?
And even when he could have been stopped, This unqualified forensic pathologist wasn't.
Institutional failure on a massive scale.
Manock retired in 1995 and is believed to be living in a retirement home. He has never had to account for his actions, nor has the South Australian judicial system and the individuals within it who, by their decisions, protected Manock for all those years.
Dr Manock's flawed testimony caused enormous harm. His incompetence undermined the South Australian justice system and ruined the lives of individuals, many of whom were already suffering the loss of loved ones.
The time has come. South Australia needs to address this issue.
Barrister Jeffrey Watson, who has served as counsel assisting at inquiries in New South Wales, believes a public inquiry or royal commission is the only way justice can be served for those impacted by Manock in his reported 10,000 autopsies and over 400 criminal cases. Not to do so, he says, would just continue the protection Dr Manock enjoyed during his career.
What we don't know is who knew what in South Australia at the critical times and why they weren't doing something about this.
The truth is, people knew.
People knew very high up in the system about the flaws in Manock's approach and his skills. The fact that they papered over it, that needs to be exposed as well. Just think about how many families Manock has ruined. Think about the lives wrecked. We deserve the truth.
And Richard, from your perspective, the fact that this hasn't been dealt with in Australia, what does it say?
Well, I have to say, I think there is a huge inertia in the state to ever face up to these problems. It's sort of too big to face. They can manage one case maybe, but this is just 10,000 cases, 400 prosecutions. It's massive.
But it's the very magnitude of the scandal, says Dr Richard Shepherd, one of the world's most respected forensic pathologists, that means an inquiry is required.
It is an awful thing to have happened, but to leave it festering is even worse. It's a boil that has to be lanced, and the state and the country have to learn from what it discovers.
The fact that Dr Manock is retired and isn't performing any further havoc on the legal system is irrelevant. It's something we should learn from.
Although Professor Bibi Sanger says some may not welcome revisiting this dark chapter in South Australia's legal history.
It's the state that should face up to the problems it has created and have an honest and open inquiry. And it's a lesson that we can all learn from.
There's no doubt at all that people who are in positions of authority and know better and should act better are failing to do their duty.
The former and current judicial officers we've named, Brian Martin, Chris Kourakis and Wayne Chevelle, all declined to speak to us. Former prosecutor Paul Rofe has since died. Dr Robert Moles has also lodged formal submissions with successive South Australian Attorneys General to open a public inquiry, including John Rao, Vicky Chapman, Michael Atkinson and the state's current Attorney General, Kaya Ma. He's been told no by each one, despite the uncertainty over every case Manock was involved in.
Because all of those cases are in question. We don't know which ones of those might have been murders. We don't know which ones of those might have been non-accidental injuries. And it's going to be terribly sad to go back to 10,000 families and say, do you know the autopsy on your loved one was done by somebody who was unqualified, didn't know what they were doing? And I can see why some people might say, well, let's not trouble them, let's just pretend it never happened. But this will always sit around as something that's going to fester and make things worse. We have to face up to it and do something about it.
Even though Dr Manock has retired, the great shame that remains is South Australia's. There are those in authority who allowed Manock to continue, even when there was overwhelming evidence against him. and those in South Australia's recent government who've refused to back a public inquiry or royal commission. I think we all agree it's time to draw a line under the man considered to be by so many as the disgraceful Dr Manock. I want to thank you all very much for joining us, and I thank you. I'm Liz Hayes. Good night. Hello, I'm Liz Hayes, and thank you for watching Under Investigation. Subscribe to our channel now for exclusive clips, and don't miss out on full episodes of Under Investigation on 9Now and the 9Now app.